Recording. Okay, we're now being recorded. And last week we were doing civil litigation. This week we turned to criminal law and procedure. Criminal proceedings are not typically referred to as litigation. Litigation being reserved for disputes between individuals and businesses, or businesses and other businesses, but private litigation. Criminal law is public law, not private law. And the government is always the plaintiff, if you will, in the case. They're not called a plaintiff, but they function in the same place as the plaintiff. And we call criminal proceedings prosecutions, because that's what they are. There's always a prosecutor representing the government who is prosecuting the case. So litigation for civil cases, prosecutions for criminal cases. Give you that bit of a preview. We'll talk about professional opportunities, as we always do in criminal law. Identify and describe the parties and attorneys to a criminal action. Describe pretrial criminal procedure. We'll walk through a criminal trial, the steps in a criminal trial, which are similar to civil litigation. List and define the essential elements of a crime, which are, there's similar elements to a lot of crimes. Describe the most important common crimes. And then we'll review some of the constitutional areas that pertain to criminal law. The Fourth Amendment, protection from unreasonable search and seizure. Fifth Amendment, privilege against self-incrimination. The Miranda rights. Sixth Amendment, right to public jury trial. Representation. Explain the paralegal's duty to report criminal activity at the end when we get there. All right, professional opportunities in criminal law. You've got basically one of two directions to go. We have a prosecution representing the government. That can be any level of government, from the federal government to the state government, county government, city government, but there's always a prosecutor. Prosecutor is a generic term. And prosecutors, like in the district attorney's office certainly employs paralegals. They've hired several paralegals from the school here in Harris County. And I'm sure that the same is true in other cities. They have legal work to do just like everybody else. So there's legal briefing to be done. Oh, you say I missed that. You said they're adding more? Tell me more about that. Add one to each felony court. Wow, that'll be great. There are quite a few felony trial courts, so that would be an excellent expansion. We've got a DA now who is pretty progressive, I would say. That hasn't always been the case. To tell you what lawyers do, a lot of lawyers, when they get out of law school, go to work for the district attorney's office. The district attorney is an elected official. They run for office. They're a politician. But the assistant district attorneys, all those who work in the prosecutor's office, the DA's office, I should say, are employees. They're hired and paid a salary, just like you would in any other job. The reason they go to work for the prosecutor is because they can do trial work sooner. If they were to go to work in a civil capacity at a large law firm, they might not get it in the courtroom for years. Whereas they have much more responsibility in the DA's office. Some of the best criminal defense attorneys in town started out in the DA's office. They handled a lot of cases, got their feet wet. They understand how the prosecutor's office works. And so then they go out and they hang out their shingle to do defense work and handle whatever kind of cases they want to handle, basically. On the defense side, before I get to the defense side, let me finish with prosecution. No, I think I am finished with prosecution. It's always a political subdivision of the government is going to be prosecuting the case. Criminal cases are different from civil cases in that there's always some risk of punishment of some sort. Punishment in the sense of going to jail, going to prison, doing community service, paying a fine. There are several different things that can happen as punishment, but they all involve some level of punishment. You don't have the same thing in civil cases. Usually you're talking about money damages. And freedom, personal freedom, is not at risk in civil cases. It's always, I shouldn't say always, it's most often the case in criminal cases that freedom is on the line. So it's a big deal. On the defense side, you've got a couple of possibilities. There are not any really large criminal defense firms that I know of. They're either small boutique firms, and I'm talking 3 or 4 lawyers, five maybe, but small law firms who handle big ticket items, big exposure. They may charge by the case, they may charge by the hour. It just depends on the type of case that they happen to be representing. So we've always had, in Texas, we've always had private attorneys handling the defense of indigent defendants. Indigent defendants are those that cannot afford to hire a private attorney. Gideon versus Wainwright, a famous Supreme Court case, determined that indigent defendants were entitled to representation and that the state had to furnish representation if they couldn't afford to hire a lawyer on their own. Therefore, private lawyers are appointed by judges to represent individual indigent defendants. The large majority of criminal prosecutions are indigent defendants. So there are a lot of appointments to be made. It's a good way for a lawyer to have a source of income, although it may not be a big source of income, depending upon how often they can get an appointment. So that's been the case. There's been quite a bit of criticism of the private defense attorney route, particularly in capital cases where the potential punishment was the death penalty, that defendants were not getting adequate representation in that method of appointment. And so really just in the last few years, Texas has gotten around to the idea of public defense attorneys, where you have a public defender's office. Dallas has had one for several years. Houston only recently, just in the last couple of years, has a public defender's office. Public defender's office employs paralegals, so that's another opportunity. Private defense firms, although small, will have we'll have paralegals working there. The problem is that a lot of the appointments go to solo practitioners, one person attorneys who handle defense cases. One attorney has 280 cases this year. Is that right, Thomas? Okay. What county is that? Oh, Oklahoma. Okay. I wasn't familiar with it, so thought it might be a typo. Yeah, it's kind of feast or famine on the defense side. Some attorneys seem to get a lot of appointments, and other attorneys may just get a few. So whether somebody can really handle several hundred cases a year adequately, that's been the issue. Two public defenders. I don't know exactly how many we have in Harris County. I know that the public defender who's I believe selected by the Commissioner's Court, and they employ assistant public defenders, of course. So they're staffed similar to the district attorney's office. So you've got two sets of attorneys, the public defenders and the district attorney's offices. The attorneys in both offices are being paid by the state, even though one side's representing the state and the other side is representing indigent defendants. So it sounds a little funny, but their duty, their allegiance on the defense side is to the defendants, not to the state. And that's just where they're getting their paycheck. But the state doesn't dictate terms to them into how they handle their defenses. So that's kind of the lay of the land. As I say, some of the best criminal defense attorneys in town started out in the district attorney's office, and they make a name for themselves. A lot of times, they go and they handle a bunch of murder cases, get a lot of convictions. I went to college with one of them that did very well in the district attorney's office. He then left the district attorney's office and ran for judge, and now he's a congressman. So I don't know what that proves, other than that it's a stepping stone to other things quite often. So you have more turnover probably in the district attorney's office than you would have in a private firm or in the public defender's office. Let's talk about the parties. They call them parties. I say they call them parties, but it's no picnic. That's kind of a play on words. But parties is kind of a strange, I don't know, I guess it's not that strange. Parties and attorneys to a criminal action. The government is always in the position of being a plaintiff. They're the government, the state. Cases in Texas would be the state of Texas versus somebody would be the style. And they are bringing the action. They're represented by prosecutors. Prosecutors, the generic term, that's not their real title. The real title would be district attorney, assistant district attorney, state's attorney, assistant state's attorney, something of that nature. On the defense side, you've got a defendant. That's the person who is being accused of a crime. And it's important in our system to realize that no one is guilty until they've been proven guilty by a jury. So while they're a defendant, they are presumed to be innocent. and entitled to the same benefits and privileges that any citizen of the United States is entitled to. It's only after they've been convicted that civil rights may be terminated or reduced, like not being able to vote as a convicted felon. The defendant is going to be represented by either a private defense attorney or a public defender, as I've said earlier. Pretrial criminal procedure, well, usually starts with an arrest. Person is taken to the intake at the jail. Information is taken down about them and the charge. There's a charge that's put on the police blotter. That's not the official charge. That's just what they were arrested for. The official charge will come in the form of an indictment, if it's a felony, from a grand jury, or an information, which is a charging document signed by a prosecutor, and use the information or a charge in connection with a misdemeanor. But indictments are still handed down by the grand juries, at least in Texas. Some states have done away with the grand jury procedure, and so they don't have indictments. They would only have informations. There's been a lot of criticism of the grand jury system. Originally, the idea of the grand jury was to serve as a buffer between prosecutors and defendants, and really a check on prosecutorial misconduct, prosecutorial abuse, that to keep a prosecutor from just charging anyone that they had a personal grudge against. Over time, since only the prosecutors get to talk to the grand jury doesn't have to talk to anybody else or listen to anybody else, they've largely become the tool of the grand jury. So that's why some states have just said, nah, we don't need grand juries anymore. I think they still serve a valuable purpose, involving private citizens in the process of should a person be prosecuted or not. I think that's an important part of the process. But their information is limited basically to whatever the district attorney tells them. And that's kind of a fallacy of the way it's set up now. All right, so you got a formal charge that's going to be filed later after the defendant's arrested and booked. We've all seen the booking photos of celebrities who've been out on a week-long bender or something, and those are somewhat amusing, also somewhat sad, I suppose. But then eventually we're going to come to the arraignment. The arraignment is when the charges are read to the defendant, and the first time where the defendant is asked to respond, the response being a plea. They either plead guilty or not guilty. If they plead guilty, then their punishment will be determined right there at the arraignment. If they plead not guilty, then a trial date will be set, and they're either put back in jail, or if they're out on bond, then they're free until the next proceeding, which may be the trial. Starting about the arraignment and for really the balance, the duration of pretrial, there's the potential for a plea bargain. Plea bargains are agreements. They're not contracts. They're not binding on either the state or the defendant. But it is basically an agreement between the prosecutor and the defendant that if the defendant will plead guilty, the prosecutor will recommend a certain sentence to the judge. And judges pretty much go along with the recommendations of the prosecutor. If a judge is not going to go along with the recommendations of the prosecutor, they have to tell the defendant that before they actually plead guilty. And they're given an opportunity to withdraw their plea if they realize that the judge is not going to accept the recommendation of the prosecutor. That happens occasionally. Usually in a case that's gotten a lot of public exposure, where the judge just feels like it's inadequate, that the punishment is inadequate for the crime. So that's it in a nutshell. There are other things that happen in there that are of some consequence, but we'll talk about those when we get to the criminal law course. Let's kind of walk through a trial. The judge, of course, presides over the trial. And you can think of the judge as being the gatekeeper of the evidence. The judge decides what the jury gets to hear. And there's several things that go into that. It's got to be the evidence before the judge will let it in has to be probative, meaning it has to prove something. And it can't be just for prejudicial purposes, just to inflame the minds of the jury. It must have real value in terms of, is the defendant guilty or not guilty? That's what probative means. It proves guilt. Doesn't have to be 100% proof. It can be circumstantial evidence. And circumstantial evidence is okay. It just is not as definite as direct evidence that actually proves a fact, like what was the weather on a given date. It's going to be whatever it was. You know, there's not usually much discussion about what the weather was. The jury is the trier of fact. They get to hear and consider any evidence that the judge allows to be admitted. And the jury is the group that weighs the evidence. The jury determines whether they're going to believe the witnesses. They determine the credibility of the witnesses. There's always conflicts in the evidence. The state will have their witnesses, the defendant will have their witnesses, and they're not going to say the same things. They're going to have different recollections about what they know. It's kind of like everybody has a point of view, and those point of views are typically different and in conflict with one another. So the jury's going to have to sort through those conflicts and determine what they believe to be the true set of facts. Never know exactly what the facts are, but their obligation is to make a judgment. If they're not to find the defendant guilty unless it's been proved to their satisfaction beyond a reasonable doubt. So much higher burden of proof, as we've talked about before, where in a civil case you just have to prove that it's a little more likely than not, and that's good enough. But in a criminal case, because personal freedom's at issue and at risk, then a much heavier burden is put on the state to prove their case. Because the prosecution has the burden of proof, prosecution goes first. They usually get to sit closer to the jury too. That's really more out of custom, I think, than law. There's nothing in the law that says the prosecutor gets to sit close to the jury, but I think it's kind of customary that that happens. So the prosecution begins their case. Well, let me back up. Criminal cases start very much like a civil case in terms of selection of the jury. That's the first thing that happens. And the next thing that's going to happen after the jury is seated is the opening statements. Opening statements by the prosecutor, opening statements by the defense attorney, which are just a general outline of what they believe the evidence will prove. The opening statements are not evidence, they're just argument, what they believe the evidence will be, what they hope the evidence will prove to the satisfaction of the jury. So we've got the jury selection, we've got the opening statements, and then the prosecution begins its case by calling the first witness. Usually they're going to call someone like a policeman, a criminal investigator, someone who was on the scene very early, what they found, sort of to set up the story, what the story is going to be, what the scene was, and then the witnesses are going to fill out the story around the framework set by the first witness. So the prosecutor will ask questions. The defense attorney may object to some of the questions, and those objections usually are based on legal objections that the prosecutor is leading the witness. When you're asking questions of a witness that you've called, the prosecutor asking prosecution witnesses questions, you cannot lead that witness by suggesting the answer. So that's what leading the witness is. Now, in cross-examination later on, when the defense is presenting their witnesses, the prosecutor can lead those witnesses in cross-examination. They can suggest an answer to them. So on the one hand, it's objectionable. On the other, it's not objectionable to lead the witness. You can do it in cross-examination, but not in the case in chief. So, hearsay is another objection that's frequently raised. There's about as many exceptions to the hearsay rule. There are more exceptions, many more exceptions than there are. The rule is the rule, and then there's a whole bunch of exceptions. So anyway, those objections are made. The judge rules on those objections, and this is part of their process of being the gatekeeper of the evidence. So it has to be probative, but it also has to be presented in a legal manner. That's the purpose that the objections serve. So the prosecutor will ask all of its questions of the first witness and then pass the witness. Defense attorney will then cross-examine that prosecutor's witness, and usually after the cross-examination, the witness will be dismissed, maybe told to stay close, be available for recall. Sometimes they'll recall a witness. And then the prosecutor will call their next witness, ask their questions. Defense attorney will cross-examine prosecutors' witnesses, and they proceed in that way until the prosecution has presented all of its witnesses and all of its evidence, and then the state will rest. Before the defense attorney begins the presentation, out of the presence of the jury, they will ask the court to enter a directed verdict in favor of the defense, in favor of the defendant. that the state has wholly failed to prove their case or wholly failed to present evidence regarding a particular element of the case. And if the judge grants that motion, then the defendant wins. The defendant is not guilty and goes home, and the case is over. If the judge overrules the motion, then the jury will be brought back in, and the defense attorney will begin their presentation by calling their first witness, asking their questions, direct questions. Then when they've finished with each witness, they'll pass the witness, and the prosecutor then gets to cross-examine the defense team's witnesses. And so the prosecutor is now cross-examining, and the defense attorney is now doing the direct examination. So they switch roles depending on what phase of the trial that they're in. One thing I might mention at this point is that defense attorneys generally do not want the defendant to testify. The reason being that the defendant is entitled to the presumption of innocence, as I said earlier, and they're also entitled to not have to testify because of the constitutional protection that they do not have to incriminate themselves. Then they have a right not to testify, and the prosecution can't say anything about that, really, because that's just an absolute constitutional right that a defendant has. If, on the other hand, and the state cannot call the defendant to the stand because they have a right not to testify. So the only way that the prosecutor is going to be able to cross-examine the defendant is if the defendant voluntarily takes a stand. So most defense attorneys don't want to subject the defendant to the prosecutor's cross-examination, because cross-examination can make you look guilty even if you're not. So, but there are exceptions where you've got a particularly credible witness who they think can stand up to the prosecutor's cross-examination, improve their case. Sometimes it's the only hope they've got is to put the defendant on the stand because there's nobody else to stand up for them. But the defense attorney calls all its witnesses, presents all of its evidence, and then the defense rests. You will possibly have some rebuttal and rejoinder. Those terms should be familiar to you. And the rebuttal is limited to whatever has been presented as new evidence in the defense presentation, and rejoinder would be limited to whatever evidence was new in the rebuttal. So you don't get to reopen everything that has gone before, only what happened in the very last proceeding before. So at that point, the judge is going to instruct the jury. The lawyers are going to present their closing arguments, which again are not evidence, they're just argument. And then the jury will begin its deliberations. The jury hopefully will reach a verdict. A verdict will be guilty or not guilty on whatever charges have been brought. If they are unable to reach a verdict because it's not unanimous, then you've got what's called a hung jury. And if the hung jury doesn't get unhung, if they're unable to reach a unanimous verdict, then the judge will have no alternative but to declare a mistrial. And then the case would have to be retried with a new jury at a later date. So hopefully the jury will reach a verdict, and the judge will then enter a judgment based on that verdict. All right, how we doing? It sounds pretty similar to a civil trial, doesn't it? In many respects. All right, let's list and define the essential elements of a crime. Every crime has elements. Elements are those individual pieces of a definition of a crime that constitute the crime. Before we were a country, the only crimes we had were the crimes that came to us from England, which were common law crimes, crimes that the definition was developed by courts over time. As we have progressed in this country, 250 years or so, there are no more common law crimes with common law definitions. All crimes today are statutory in nature. If it's not in the statute, it's not a crime. So crimes have to be very specifically defined, and that definition set out in a statute so that we all can know what it is that we are not to do. Now, not everybody sits down and reads the list of crimes and the elements of crimes, but lawyers do that and paralegals do that. So if you take criminal law and procedure in the future, which I teach, we'll spend a lot of time talking about the essential elements of crimes, those common elements that are shared in crimes, and the individual things that differentiate crimes from each other. So there's some similarities or some dissimilarities in most crimes. One of the things that is similar is that every crime will be classified as to the seriousness of the crime. The most serious crimes are felonies. Felonies generally have a potential imprisonment of 1 year or more. First degree felony in Texas is from 5 years to 99 years. That's a pretty big range, well above the 1 year. Misdemeanors typically are up to 1 year, but not more than 1 year, usually in the county jail, not going to the big house, the penitentiary. So felonies, the most severe, misdemeanors next, and then the least severe crime would be a violation, like a traffic violation, a parking violation. Those are criminal in nature, but the punishment attached to them is usually just a fine with no incarceration involved. If you don't pay your fines, you might end up incarcerated, but the initial punishment for a violation is usually just a fine. Some misdemeanors are just fines, like a Class C misdemeanor. There is no incarceration potential. It's a fine up to $500, and that's it for a Class C misdemeanor. So we have A, B, and C misdemeanors. Felonies are first, second, third degree felonies, and also capital felonies, which is capital murder is a capital felony. It's a specific types of murder have a more severe punishment attached to them. But the three you need to really remember are felonies, misdemeanors, and violations. And we call those classifications of crimes or types of crimes. A crime, another way of classifying a crime, and you don't see this in the statutes, but it's just a way that legal writers or lawyers might talk about a crime as being mala in se or mala prohibita. Mala in se crimes are those that are inherently evil. Those things that we would all agree are really, really bad things like rape and murder. Mala prohibita would be those things that are prohibited by society but not inherently evil, like trespassing. We don't want people trespassing on our property, but it's not inherently evil that somebody wants to go fishing in somebody else's pond. You know, so our parking tickets. There's nothing evil about, overstaying your limit or parking in a place that you're not supposed to park. There's nothing inherently evil about that. Or even speeding. I would not say that's inherently evil. A lot of people speed. It's prohibited. We need it for an orderly society to not speed, and yet, a lot of people do. But I wouldn't call it mala in se. Now, if you're speeding and you're drunk out of your mind, I might think that's inherently evil. Very, very thoughtless, certainly. Well, you see, these are open to discussion as to what's inherently evil and what's merely prohibited. And if you look at crimes over time, you see variations in the way that people think about certain things. Like before the turn of the century, between the 19th and the 20th century, early 1900s, there were no drug crimes, none. You could buy whatever drug you could find and had the money to purchase. Well, it's a far different world we live in now, but that was the way they viewed it then. Another example would be prohibition. When we went through a period of time where it was illegal, actually unconstitutional, to consume alcohol or to sell alcohol. And we've changed our minds about that. So over time, different societies, different civilizations, different citizens, and different viewpoints, criminal law will change to reflect the public. You can see those kind of changes going on in Colorado and some of the places that are changing their mind about marijuana, that it's not the boogeyman that some would still classify that as inherently evil, probably, whereas others would say, well, no, it was prohibited, but it shouldn't be prohibited anymore. So if it's in the prohibited class, then it's open for discussion. If it's in the mala in se, there's probably not going to be much discussion about that. Youngling, I didn't know that. That's interesting. Adolf Coors had something, there was something about that too, which I can't remember. I guess that was after Prohibition, must have been. Was it, So it existed before Prohibition and during Prohibition, or just it started back up after Prohibition? Oh, okay. Well, interesting stuff. Did not know that. All right, we're getting to the common elements. Um, Actus reus and mens rea are two elements that you will find in a lot of crimes. Actus reus is a criminal act, an action. It could be shooting a gun, it could be stabbing somebody, it could be stealing money, but it's an activity. Possession is defined as an activity for actus reus purposes. But there will be something that is defined as a criminal act. Maybe a sex act in sex crimes. Mens rea is a criminal state of mind, sometimes called criminal mind, sometimes called criminal intent, although intentionality is only one of the potential mens reas. There are other mens rea other than intentional. The Model Penal Code has 4 different states of mind. There's intentional, knowingly, and the difference between those is, well, just know that they're different. Intentional and knowing, there's recklessness. There's one more, which is a lesser state of mind. Criminal negligence is the other one, which is a little less than recklessness, but still more than common negligence. Common negligence being like the negligence that someone would have in a traffic accident. Most traffic accidents are not criminal in nature. They're just accidents where somebody was not being careful. But not being careful does not generally rise to the level of criminality unless, a police officer comes and assigns blame to one of the parties or the other, and then there's going to be a ticket. If they're found guilty on that ticket, then that establishes their responsibility civilly as well as criminally. But crime after crime after crime has both an actus reus and a mens rea. With murder, for example, murder is the killing of another human being. That's the actus reus. I guess I should say the unjustified killing of a human being. It has to be a criminal homicide versus a justifiable homicide. Justifiable homicide meaning to self-protection, protecting somebody else, responsibility to do the act. Anyway, that's the actus reus of murder. Now, but it's not murder until you establish the mens rea, and the mens rea is to intentionally or knowingly kill some other person without justification. Intentionally or knowingly. Now, how do you know whether it was intentional or knowingly? Well, we can presume that. We can, if the actus reus, if the action that was taken, that's really all we have to go by, is what people say and what people do. And in order for it to be murder, it has to be intentionally or knowingly. Now, you could have someone killed, I don't mean have someone killed, hire a hitman, that's not what I mean. But someone could be killed and it be an accident, and it would only be criminal if the accident was due to criminal negligence or reckless behavior. Still doesn't make it murder. It would be manslaughter. Still have the same actus reus, but the mens rea, the mental aspect of it, is different between murder and manslaughter. But the way we determine the mens rea is by what they say and what they do. That's all we have to go on. And then we can deduce that it was intentional or knowing, or that it was criminal negligence, or, the jury can draw a conclusion based on what was done and how it was done. Nearly all crimes have a mens rea. There are exceptions. Sometimes, like intoxication crimes. Intoxication crimes in Texas do not have a mens rea. There's no investigation as to whether a person intentionally got drunk or knowingly got drunk. The only thing that's determined is, were they drunk? If they were drunk and if they assaulted someone, then they're guilty of intoxication assault. If they were intoxicated and they kill someone, then they're guilty of intoxication manslaughter. So there's no mens rea. Doesn't matter what their state of mind was. Another one is statutory rape. That in many definitions of statutory rape, the knowledge of the age of the female, the knowledge of the actor of the age of the female is irrelevant. And it would only be intentional, if intentionality was required, it would only be intentional if they knew that the victim was underage. So for that reason, mens rea quite often is not part of that statute. Just if the female is underage and have sex with a female underage, that's statutory rape, regardless of one's state of mind or what they believed or thought. So there are some crimes that don't have mens rea attached to them, but most of them do. And each crime will be separately defined. It will state the mens rea that's required in the statute, and it will also state the classification of the crime as either a felony or a misdemeanor or a violation, the degree of punishment attached to that particular crime, or the range of punishment attached to that crime. So all that's in the statute. Something that happens and it's not in a statute, not a crime. It's only a statute. It's only a crime if it's in the statutes. That's where we are in criminal law. Now, there's another way to classify crimes is to whether they're specific intent crimes or general intent crimes. And actually, we're getting into different levels of mens rea in a way. Specific intent crimes are crimes that intend a particular result. They intend not only the act that is done, but they intend to do the act with accomplishing a specific result. So murder is quite often called a specific intent crime, that the person, whatever it is that they're doing, they intend to kill, or they intend to hurt someone to such a degree that they might die. But it's that specific intent to hurt or to kill that's part of murder. general intent crimes, there doesn't have to be an intent to accomplish anything. It's just intent to do the act. So they intentionally shot a gun, but they didn't intend to kill anybody. They didn't intend to, even wound anybody. But the act of firing a gun intentionally can be criminal regardless of the result or regardless of the intended result. So just different ways of looking at intent. Either and these are also go into the definition of the difference between intentional and knowing. Um, you can intend to do something without intending the result, but if you do something knowingly, you do it intending the result as well as the intention to do the act. All right, we'll look at some crimes. Let's do that after the break. We're right at 8 o'clock, so we can come back at 10 after and easily finish up what we have left here. So enjoy your break. I have 10 after 8. So let's continue. Most important common crimes. I don't know why they call them common crimes. Common crimes, yeah. Mayhem's not a common crime. But anyway, crimes against the person. When we get into criminal law, you'll see that they're classified in different ways, like crimes against a person, crimes against property. Sex crimes sometimes are treated differently, although they're crimes against a person. Murder and homicide crimes are typically treated as something separate as well, although there are also crimes against the person. And then there's crimes against society or orderliness of society. But starting here, crimes against the person, assault and battery, which are also torts being civil wrongs, crimes being public wrongs. And there's some overlap between civil wrongs and public wrongs with respect to intentional torts and some intentional crimes. Assault and battery. It sounds like one thing. It's actually two things. Battery is the intentional, non-consensual touching of another human being. The intentional touching of another human being without their consent, which is hurtful or not necessarily hurtful, but it can be obscene is not the term. Well, anyway, it's intentional touching of someone. It can be a forceful blow, or it can be something that's simply undesired, offensive. That's the word I'm looking for. Either hurtful or offensive touching of another human being without their consent. So it could be hitting somebody, clobbering them. It could be just touching them in a way that they find to be offensive. Either one being a battery. There's even a medical battery which is a tort, where if a doctor operates on the wrong body part, then they've touched a part of the body without consent. So it's the same idea. It's a battery. The assault part, it's actually a separate crime from battery, but they frequently occur together, and that's why they're frequently referred to together. But an assault is the anticipation, the apprehension, and anxiety that's created by a battery, by an actual battery, or by a threatened or attempted battery. You can be just as scared by somebody threatening to hit you as if you actually get hit. Threatening to do bodily harm to you can be very can cause a lot of anxiety. So the assault is the mental apprehension or fear that's created by a battery or by a threatened or attempted battery. So it doesn't have to be a completed battery. It could just be, watch it, or I'm gonna do something really bad to you, and they're serious about it. It's not a joke. You're going to experience some apprehension around that. Whether you actually get clobbered or not. Okay, mayhem is not a familiar crime that you hear much about today, because in most quarters it doesn't exist today. It would be part of aggravated assault. Mayhem involved the dismemberment or intentional scarring of someone, like throwing acid in somebody's face, cutting their face with a knife, cutting off some part of the body so that it was no longer of any use. That was mayhem. A really bad assault and battery. But we very few. I don't know of any state that currently has the crime of mayhem. It would be aggravated assault. Would be mayhem. Rape. Here's another crime that you don't see as much anymore. That's cast in terms of rape. And there's a lot of reasons for that, because there were a lot of anachronisms and weird ideas associated with the crime of rape. First of all, rape was a sex by a man against a woman, period. A man cannot be raped. A man cannot be raped by a man. A woman could not be raped by a woman. It was a man on woman crime, plain and simple. There had to be penetration in order for it to be rape. A man could not rape his wife. That was one of the weird ideas that had grown up around rape, because a wife, when they got married, had consented to sexual contact, so there's no such thing as non-consensual sex in a marriage, which is a weird idea. At any rate, and there's others that we could talk about, but today, modern criminal codes, you would see sexual assault instead of rape, and it would be gender neutral. It could be a man against a man against a woman against a man, woman against a woman. It does not matter. It could, and the type of sexual activity has been expanded. With rape, it was only penetration. Now it would include oral or anal, which was not part of rape. So it's been expanded and degenderized to be more inclusive. Sexual assault and aggravated sexual assault, taking the place of rape, statutory rape, and child molestation. Kidnapping. You may or may not know the large majority of kidnappings are by the non-parental parent, the non-custodial parent, not the non-parental parent, the non-custodial parent, of stealing the child away in violation of a court order. It's a large majority of all kidnappings. There does not have to be any ransom demand for it to be a kidnapping. If there's a ransom involved, then it's aggravated kidnapping. But kidnapping is simply stealing away someone against their will without a right to do so, hiding them, secreting them. And then if there's injury involved, then it becomes aggravated. Or if there's ransom involved, aggravated. Deadly weapon involved, aggravated. Murder, we discussed, basically killing someone with intentionally or knowingly. Consent is not an element of murder. Non-consent is not an element of murder. A person cannot consent to their own murder. I cannot say, will you please kill me? You kill me, you've committed murder. It makes no difference that I asked you to do so or consented for you to do it. it's still murder. Interesting little tidbit. These are generally crimes against property. Some would be crimes against habitation, a place where people live. Robbery is, there's theft involved. Larceny is theft. Larceny is pure theft, taking something that doesn't belong to you. And larceny is punished on the basis of the value of the thing stolen. So if you don't steal very much, the punishment's not very severe. If you steal a whole lot, then the punishment's more severe. That's larceny, theft. Theft by itself. Burglary and robbery have an association with larceny or theft, but they're different. Robbery is intentional theft. It's personal theft. It's theft from a person. A bank robbery is where a robber goes in and faces a teller and says, "Give me all the money in the drawer." That's robbery. It's face to face. The stick up, the gun in the ribs, "Give me your wallet." That's a robbery. It's personal theft, personal confrontation. And robbery is punished based on the degree of violence employed in the theft. So it doesn't matter how much was taken. It could be 50 cents and still be robbery if it was taken from one's person. If there's elements of aggravation like using a deadly weapon, making threats, things of that nature, then it's aggravated robbery. Burglary had an early association with theft, but in its early history, it was only burglary that occurred at night. Breaking and entering one's habitation house at night with the intent to commit theft. That definition has changed quite a bit. It no longer has to be at night. Burglary can be any time of day. It's still breaking and entering, but the breaking and the entering have been watered down to something like crossing the goal line in football. It's breaking the plane of the doorway or of the window. Even sticking something inside the house without any part of your body intruding into the house. Like there's a ring on the kitchen sink, the window's open, get a stick, push it through, get the ring. No part of their body entered into the house. The window was open, so they didn't have to break anything, but they broke the plane, the goal line, and therefore it's breaking and entering, in addition to larceny. The other thing that's happened with burglary is it's no longer exclusively theft. It's breaking and entering with intention to commit a felony or a theft or an assault. Now, the reason theft and assault were specifically put in there distinctive from felonies is because theft and assault are not always felonies. Sometimes a simple assault is a misdemeanor, and a theft of a small amount of value may also be a misdemeanor. But when it comes to burglary, it's the intention is to commit a felony or a theft or an assault. Doesn't matter the time of day. But the way I think of it, burglary is breaking and entering. There's somewhat of an association with theft, but not so much anymore. Um, larceny, theft, robberies, personal theft. Arson, everybody knows what arson is. Arson's burning down something that doesn't belong to you, or burning down something that belongs to you with intention of committing insurance fraud, or getting out of paying your mortgage, or something like that. Just starting a fire within the city limits can be arson, even if it doesn't burn anything down. If there's no permission, no, depending upon how the code is worded, arson in a municipality is pretty much starting a fire inside the city limits. Forgery is creating a false document, a document that purports to be something other than what it is, like a driver's license, a false driver's license, a false birth certificate. And if you actually try to pass the forgery, it's called an uttering a forgery. Uttering. I don't know where that term comes from, but extortion is blackmail. Holding something, threatening to reveal some secret, some hidden truth about someone. Demanding money in order not to do so. It's blackmail, extortion. Embezzlement is a type of theft, and in a lot of states, embezzlement has been put together in the theft statute as no longer a separate crime, but is just a part of theft. What it meant, what embezzlement is stealing something that you already have lawful possession of. So it's taking lawful possession and turning it into unlawful possession. Possession with the intention of depriving the rightful owner of possession. So think of a bank teller. They're in possession of other people's money. If they take money out of a customer account, put it in their own account, that's embezzlement, because they were lawfully in possession of it, but when they put it in their own account, their intent was to deprive the rightful owner of the possession of the funds, and to have exclusive possession of it. So that's embezzlement. They had lawful possession, but they turned it into unlawful possession. Whereas theft is, there is no lawful possession before it's taken. So that's really the only difference between embezzlement and theft. Criminal fraud is some type of misrepresentation in order to obtain some benefit, money, status, but misrepresenting material facts in order to obtain a benefit that you're not entitled to. Bribery, giving money or other things of value to usually a public official, could be a judge, could be a juror, could be a political representative, a mayor, a congressman, senator. Giving money or something of value in order to obtain a special special benefit, special treatment. What's the difference between bribery and campaign contribution? It's reported. I don't know how else to tell you the difference. Campaign contributions are reported. Bribes are not. The difficulty with proving bribery is the quid pro quo, that is, the something for something else. You can prove that money changed hands or value changed hands, but proving that something was done that would not have been done but for the special benefit, that can be more difficult to prove. The best way to prove it is to have surveillance tapes that show the evil intent in the campaign contribution or the whatever the valuable thing was. Conspiracy, the essence of conspiracy is an agreement to commit a crime. Two or more persons agree to commit a crime. And that's a criminal conspiracy. Now, conspiracy doesn't mean much by itself. It has to be conspiracy to do something, conspiracy to commit theft, conspiracy to commit murder, conspiracy to do something. It has to refer to something else. So it's one of the crimes that doesn't stand alone, but has to refer to some other crime. All right. Well, that's kind of a brief introduction to crimes. Of course, there are many more crimes than that. Those are some of the basic crimes that we talk about. But we spend quite a bit of time talking about the origin of crimes, what they originally were under the common law, and what they've come to mean under modern statutes. And that serves a little bit of history as well as, what's happening now. All right, let's talk about part of criminal law, criminal procedure deals with the Bill of Rights, because a lot of the amendments have to do with rights of those accused of crimes. Not rights of criminals, but rights of persons who are accused of crimes. So you have these rights simply by virtue of being a citizen or being subject to American justice. Fourth Amendment is a protection from unreasonable search and seizure. And the Fourth Amendment is a big topic, criminal law, criminal procedure. I don't have the whole, it'd be nice if I had the amendment in front of me, but basically it's a prohibition against unreasonable searches and seizures. And that searches and seizures will require probable cause. There's reference to warrants in the Fourth Amendment, but the warrant language has not been given nearly as much weight as the probable cause language. There are many instances where searches and seizures can be made without a warrant. Now, in certain situations, particularly when the right of privacy is an issue, like in one's home, there is a greater requirement for having a warrant before a policeman, a law enforcement officer enters into one's house. There are some exceptions that will allow that, but they are relatively few. In other settings outside of one's home, where your right of privacy is the greatest, for example, in a car. Now, at one point, cars were considered to be a place where you had an expectation of privacy, believe it or not. There's not much expectation of privacy anymore, even with the tinted glass, at least as far as the law goes. So law enforcement can do more with a person in a car than they can do in their house. Well, part of it is, if a law officer makes a traffic stop, the motorist rolls the window down, they can see in the car, they can smell in the car. Anything in plain view, or anything that can be detected with the five senses, that includes smell, can be a basis for entry and or seizure of contraband. So if they see a roach in the ashtray, or they see a gun on the seat, anything like that that's in plain view, they can seize without a warrant. Just their five senses can give them probable cause in a car. Not so in a house. Looking in the window is not considered good policing. It's more like being a peeping Tom. So there is a greater right of privacy and a greater requirement for having a warrant. Warrant, of course, is where a police officer will do an affidavit as to what they wish to search and why. And that affidavit is reviewed by a magistrate, a judge, and the magistrate determines that the affidavit constitutes probable cause. If the judge doesn't believe that there's enough there for probable cause, then the warrant's not issued. So the warrant is issued by the court based upon the affidavit of a police officer. One of the big exceptions to warrantless searches and seizures has to do with arrests, where something is witnessed, where they're relying on identifications or reports of other officers as to what a subject was wearing, or a description. They can use that as a basis for stopping somebody and potentially arresting someone, even though they didn't see it themselves. They can rely on other police officers, things that go out over the police radio. And it just makes sense that a police officer wouldn't have to go and get a warrant to make an arrest of someone that they saw committing a crime, or someone that they believed had committed a crime. If they're trying to get away, resisting in any way, high-speed car chase, or throwing things out of the car, they can things that are in the trash, they can take those things without a warrant. Evidence is likely to be destroyed. So another category. Incident to arrest, even incident to a stop, called a Terry stop. It's It's a brief detention for purposes of making a brief interrogation, a brief investigation. Now, what's brief to a citizen and what's brief to a police officer may well be two different things. And the courts have not put any particular time limit on a temporary detention that's not an arrest. It's just a temporary detention for purposes of an investigation, a brief investigation. It's however long the investigation takes. So it could be longer than you think. But incident to a brief detention, they could do a pat-down search of the outer clothing looking for a weapon. It's for the officer's protection. To know, that who they're interviewing or talking to is not armed and might be trying to hurt them. And then incident to an arrest is a seizure. Fourth Amendment refers to searches and seizures. Seizures of evidence, seizures of persons. An arrest is a seizure of a person. So the Fourth Amendment applies to both arrests and seizures of evidence. And about 2/3 of all criminal procedure law deals with the Fourth Amendment. What police can do or can't do, and there's actually, when we're talking about can and can't, you have to define what you mean by can and can't. Can is anything that they can get away with, okay? I mean, they have the ability to do whatever they can do, whatever they have the ability to do. Can't is talking about what they legally cannot do. Doesn't mean they can't actually do it. It just means they cannot legally do it. But police can do whatever they want to. When you get right down to the reality of the situation. And they also back each other up. So, it's tough to go against the system, but there are these constitutional rights that help to counter the weight of government and the ability of government to intrude on private activity. That's really what the courts are weighing whenever they look at one of these decisions is what is the degree of privacy that one is entitled to, and what is the benefit, or is there any necessity to intrude on that right? Is this important to law enforcement? So you're weighing those, the rights of government, the rights of the individual. The courts are weighing that constantly in these Fourth Amendment cases. And whatever evidence is found to have been obtained illegally, that is unconstitutionally, can be kept out of any trial. And so there's a huge incentive to criminal defense attorneys to raise Fourth Amendment issues in the hopes of being able to limit some of the evidence against the client. Rarely does it result in all evidence being eliminated, but it just reduces some of the evidence that may be admitted. If they would have found the evidence anyway, and you get into all kinds of circumstances, if they would have found this evidence anyway through legal means, then they can still use the evidence. Sorry about that, Maria. I'm sorry you can't hear anything. Sorry. I'm sorry. I'm really sorry. But she can't hear my apology. So, but I am very sorry. All right, Fifth Amendment, privilege against self-incrimination. We all know about that. That it's because of this Fifth Amendment privilege against self-incrimination that defendants do not have to testify at a trial. And they can't be called by the prosecution. The prosecution can't comment on the fact that they are not testifying, that if they were innocent, they'd be up here testifying as to their innocence. That's mistrial stuff. They can't comment on their testifying or not testifying. Miranda rights come out of the Fifth Amendment in a very direct way. No person shall be compelled to be a witness against himself. Miranda, you have a right to remain silent. Anything you say can and will be used against you. You have the right to have a lawyer present at any interrogation. If you cannot afford a lawyer, one will be appointed free of charge. And that's basically the Miranda rights. We've all heard them on TV and movies ad nauseum. And you'd think, well, everybody knows their Miranda rights by now. Why do we keep? Well, not everybody does know. Believe it or not, they still don't know, and need to be reminded anyway. Miranda rights basically apply in a custodial interrogation. Miranda rights have nothing whatsoever to do with a legal or illegal arrest. Nothing. It only has to do with whether information obtained in a custodial interrogation can or cannot be used. If the Miranda's been violated, you're not going to be able to use custodial interrogations. So that's the weight of Miranda. But if a person is not Mirandized, doesn't mean that they've been illegally arrested. Has nothing at all to do with arrest. In addition to not incriminating oneself, the Fifth Amendment also prohibits double jeopardy, which is being tried twice for the same crime. So Fifth Amendment's a double duty, double jeopardy, and right to remain silent and not incriminate oneself. Sixth Amendment is a bundle of rights for those accused of crimes. Right to have a jury, right to have an impartial jury, right to the assistance of an attorney during a trial, and that's all throughout a trial. There's another right elsewhere in the Bill of Rights, but this is the primary one. Right to a speedy trial, right to confront witnesses against the defendant, and the right of confrontation, as it's called, has also well, it's construed quite literally that in order for a defendant to confront the witnesses against him, the witnesses have to come to court and testify eyeball to eyeball with the defendant. The only exceptions being in the case of young children who've been molested, and to have to confront the person again would be to re-expose them to the abuse. So they're allowed to testify in a room with a psychologist there and a video kind of thing, where they're asked some questions and in in a more gentle atmosphere than that of the courtroom. But everybody else has got to come to court, and depositions are no good in criminal cases, because if the defendant is in jail, the defendant has a right to confront the witnesses against him. So you take a deposition, you're not going to be able to use it if the defendant was not there to confront the witnesses during the deposition, and they don't let them out of jail to do that. So quite often the depositions can't be used. So consequently, there are not a lot of depositions taken in criminal practice, not as many as you do in civil. A right that some call the most important right the defendant has, that grows from the Confrontation Clause, is the right of cross-examination. And many would say that is the most important right that a defendant has, to call into question witness accounts against them. All right, well, that's a brief overview of criminal law, criminal procedure. We managed to talk about it for 8 weeks in criminal law and procedure. So there's much more that we could be talking about, obviously. It's a very interesting subject. I enjoy teaching it. One of the reasons I enjoy teaching it is because it's happening every day all around us. So it's very current. There are things going on in the news that make it interesting to talk about a particular subject at a particular time. I know one time in class we were talking about DNA, and DNA can put a person at the scene, and because no two people have the exact same DNA. They may have similar DNA. You're going to have similar DNA with your relatives, but it's not going to be identical. The only exception being if you're an identical twin. And while we were talking about that, there were a couple of identical twins that were charged with a sexual assault that was going on right here in Houston. And how could you, if you had an evil twin and a not evil twin, how would you ever prove through DNA? You couldn't through DNA which one of them was the actor. As it turned out in that particular case, one of them admitted involvement and testified against the other one. And that was the only way really that they could have convicted them based on the DNA evidence, because they had identical DNA. Well, let's talk about a paralegal's duty to report criminal activity. We're not talking about a confession that the defendant makes. that would be covered by attorney-client privilege, and could not be divulged. There would be an absolute prohibition because the attorney-client privilege belongs to the client, and only the client can release the attorney or the paralegal from the attorney-client privilege. There's an interesting case that you're going to be exposed to. There was a video on CBS that I wanted everybody to watch about the case. This was a man who spent 26 years in prison when another man had admitted to his attorneys that he had done the crime. And the attorneys who had that information were duty bound by the attorney-client privilege not to reveal that information without the consent of their client. They begged and pleaded their client to allow them to reveal the information, and the client would not. And so somebody else was convicted for the crime that their client did, and spent 26 years in jail for it. A crime that he had not done. So anyway, you're going to read some about that. The video, CBS has changed its policies. This was a 60-minute presentation, and now they've got it's subscription based. So if you don't want to sign up for the subscription, there is a transcript of the 60-minute piece, and it's down below where the video would have been. You can also get more information about it just by Googling the man's name, and man wrongfully imprisoned for 26 years. We'll probably turn it up on Google. Anyway, you have a chance to discuss that. I think that should be a lively discussion. It's interesting. Anyway, the point is, your duty to report criminal activity is not what the client tells you. If the client admits to having done a crime, you're duty bound not to report that, not to even reveal that. If, on the other hand, the client, or anyone for that matter, tells you that they are going to commit a crime, and it might be, a criminal defendant who says they're going to take care of a witness, they're going to take them out. Don't have to worry about that witness. They won't be around at trial. That's a whole different thing there, because if you don't report that, then you're potentially an accessory to a criminal act. So the duty to report criminal activity is prospective criminal activity that appears to be imminent, that there's a clear threat or a clear announcement of intention, then that they're going to do something, then you have a duty to do something about that. If the first thing would be to tell the supervising attorney about it, and hopefully the supervising attorney will take action, but you can't just put it off on the supervising attorney either, because you're an individual. Anybody can be an accessory. You're not protected from being an accessory simply because you're working for an attorney. So, but it's only when it's prospective in nature, in the future. If they've already done it and they're admitting something they have already done, then you do not have a duty to report that. Okay, well, that's all I got, folks. It's been a pleasure. The almost 100% of you, maybe not quite 100% of you, but almost 100% of you are in a very good position to make an A or an A plus. I think that's some kind of record. So y'all have been great. You've done a good job. You've worked hard, and you deserve that grade. So I don't have any problem with having a whole bunch of A's. That's fine with me. I'm really, really happy about that. So congratulations. Don't sit on your laurels and do nothing this week. That would be the worst thing you could do, because that could be enough to, put you in the B category. So stay with it. Get it done early. Sunday night, 6 o'clock. That's the deadline. That's the school's rules, not mine. Okay. So have a good one, and I'm sure I'll see y'all later somewhere. I teach corporate I teach wills, trust, and probate, and I teach criminal law and procedures. So I'll see you in one of those courses, I'm sure, in the future. So go forth, do good, continue to do good. I wish you all success, and we'll see you on down the road. Night, everybody.